probably all aware, while we've allocated 20 minutes to a side, it's likely to go beyond that. So if you do, and we're still asking questions, don't worry about that. That doesn't cut into reply time, and you need not ask for permission to exceed your time. So let's begin with counsel's appearances.
Martha Pierce, attorney guardian ad litem for the minor children. With me is Heath Hackey, also an attorney guardian ad litem.
John Peterson, assistant attorney general for the state of Utah.
Shelley Harding, appearing for the father, who is not present. And thank you for permitting me to appear virtually.
We appreciate your doing it and hope you feel better soon. Okay, let's go ahead and start.
May it please the court, Martha Pierce, attorney guardian ad litem for the minor children. I would like to reserve 5 minutes for rebuttal. The Court of Appeals erred by tying best interest to 80-4-104, the first provisions 1 through 10, and by failing to tie best interest to the mandatory statutory factors in 80-4-303 and -304. In addition, the tests that the Court of Appeals applied, the harmfulness test, the carve-out for relatives, all of those tests are not reflected in the plain language of the statute. I welcome this court's questions at any time, but specifically, the Court of Appeals tied best interest to 80-4-104 sub 8. And that sub 8 presents the presumption that a parent is presumptively fit. It is in the best interest of a welfare of a child to be raised under the care and supervision of the child's natural parents. But then the provision finishes by saying, for these reasons, the juvenile court should only transfer custody. Well, right there it tells you that provision is about transferring custody. And usually custody has long ago been decided. We're not determining custody at the termination stage. But it says should only transfer custody if there is a jurisdictional basis to do so. Now, in the context of juvenile court proceedings, the jurisdictional basis for a juvenile court to have the power to transfer custody is an adjudication of the child's status as abused, neglected, or dependent. So I would suggest that definitely subsection 8, you cannot tie that to the best interest standard, because once you adjudicate the child's status, the parent is no longer presumptively fit.
So you're citing there to 80-4-104, correct?
Right.
What about 80-2A-201, where it talks about it being in the child's best interest to be raised by natural parents? And I take your point that it's really important to have this be from the child's point of view and focused on child's best interests and not the parents. But if the legislature has seemingly made a policy judgment that, one of the factors that weighs in the child's best interests is being raised by their natural parents, why isn't that appropriate for the court to consider?
Well, this language, when you're referring to 82A, that used to be 62A4A, and I think it was 201. So that's been in the statute since 1992. And this court in In Re WA, and again in State versus Kilpack, has held that provision applies to, that's just a statement of constitutional principles, not application of the principles that apply to presumptively fit parent. And also 2A, that goes, I think for the most part, 2A is referring to matters that happen prior to adjudication. So at that point, the parent is still presumptively fit because it's talking about pre-adjudication removals and what the division can and cannot do.
But isn't the entire reunification scheme and the services that are provided, isn't that all to take a presumptively or a parent who has been deemed unfit and, if at all possible, get the children back into that home?
Well, first of all, that question assumes that reunification services are presumed. And there's a lot of circumstances where there's a presumption against reunification. One of them is abandonment. One of them is severe abuse and neglect. And then there's a few more that are listed under 80-3-409, and there's several listed in 80-4-203 where there's a mandatory petition. So reunification services are not always presumed, and the Court of Appeals found in In Re NR that there's no constitutional right to those services, but they are a gratuity provided by the legislature. On the other side, in most cases, yes, you do want to provide the services, you do want to, because the best interest of the child is to be able to reunify if that's at all possible. So the answer to your question is a little more nuanced.
But I guess what you said at the end is what worries me about just excluding this policy statement, that it's in the best interest of the child to be reunified if that's at all possible. So that seems like something that is proper for the court to consider even after the parent has lost that presumption, right? Or the constitutional right to be reunified with the child.
Well, if you're looking at that in the context of services,
Okay.
services end as a matter of law at the 12-month mark. And whether or not you're going to continue to provide services, that's all determined at the permanency hearing, which is under 80-3-409. So the idea of whether or not we can still reunify, that's a done deal. That's already been determined at the permanency
I'm sorry,
hearing.
Ms. Pierce, if I could interrupt you for just a minute. I'm wondering if we still have the video feed.
Yeah, they're still on there. Just give me a second.
She may have turned off her camera.
I'm here and I can see you.
Okay, let's continue.
Okay, and sometimes we have a direct file, so sometimes you directly file a termination petition, but even then, the legislature now provides for custody to be litigated and for services to be litigated, and that's all provided for in 80-4-100s.
And I apologize, and I appreciate you clarifying this for me. So when we say that it's in the best interest of a child to stay with their natural parents if they are fit, right? If they're fit and competent parents. At what stage do you think that that's no longer a consideration? When the parent is first adjudicated to be unfit at the outset, or at the permanency hearing when they haven't been able to remedy the circumstances that caused the child to be removed?
This court answered that question in the case of In Re MW.
Okay.
And this court determined that the initial adjudication was sufficient to rebut the presumption of fitness. This court again made that determination in Re KF, where it said that an adjudication of abuse, neglect, or dependency was sufficient to rebut the presumption of fitness in custody. And that's what gives the juvenile court power to provide any of the dispositions under 80-3-405.
Okay, so the parent loses the presumption at the initial determination that they're unfit. So then we go through the unification services, and if those are successful, isn't the presumption to still return the child to the parents? I'm just wondering why the court can't consider this legislative mandated policy that it's a good thing, if at all possible, for a child to return to their natural parents.
Because generally by the time of the termination hearing, the child's permanency goal has changed. Initially, the child might have a permanency goal of return home, but at the 12-month mark or sooner, but no later than the 12-month mark, the court has to make an up or down decision, can the child return home? If the child cannot return home, and we're not going to talk about statutory extensions right now, but then 80-3-409 sub 4 says the juvenile court must then change the child's permanency goal. So the child's no longer under a permanency goal of reunification, and the legislature has said that we can no longer have a reunification goal at the 12-month mark unless there's a statutory extension. So we're no longer working under that presumption.
Because there is no possibility that the child's going to return to the custody of the unfit parent at this point. This is simply, like in this case, a matter of whether there's going to be termination for an adoption or permanent guardianship.
Exactly. Because you've already litigated the issue of what the child's permanency goal should be and whether or not reunification should still be the child's goal. But the legislature has made it really, you can terminate services at any time for any reason under 406 and 409. It gives the court broad discretion to terminate services at any time. It limits the court's discretion to order services. You have to find it's in the best interest, and it says you don't have any discretion to order services beyond the 12-month mark unless you can show the factors in 406 sub 7, 80-3-406 sub 7. So that's already been litigated at that point.
I'm sorry. Are you finished, Justice Hagan?
Oh, yes, thank you.
Can I take you to Title 80, Chapter 4?
Okay.
Okay, so one question I have, you argued in your brief that the juvenile court should have considered both
303 and 304.
303 and 304. And so one question is, in 304, it's talking about specific considerations when child is placed in foster home.
Mm-hmm.
Do those apply in this situation?
I think at this point, the child was placed with grandmother, but not in the custody of grandmother. So DCFS still had technical custody. So, and the child was under a permanency goal of adoption, so I would say they do. And even if you were to say they don't, the juvenile court is not precluded from making these considerations.
Okay.
Because they're all very, if you look at them, they're all very point of view, they're all very fact intensive, they're all very specific to the child, and they're all very developmentally oriented.
Okay, so just because, I think to someone who is not in the juvenile world,
Which is most attorneys.
which is
Judges,
most of us,
yeah.
when I hear foster home, I'm thinking of an official foster home that has, that is contracted with the state and they are foster parents and the child is in the foster system. And I think of the grandmother as not being that.
I think that's true for everyday parlance, but that's not true under the juvenile code because even relatives need to be licensed as foster homes if they're still in
Okay.
division placement. So there's no carve out for relatives.
So the being in the grandmother's home was a foster care placement?
That's my understanding.
Okay.
But even if it were not, I would say the juvenile court is still not precluded from making these considerations. And the other tests that the court applied, like the harmfulness test and the cut out of their life completely test, none of that is reflected in the statute. And I think we need to go back to the plain language. Even the present tense, even the admonition to look at the present tense, that's helpful, but some of the factors are past tense, some are look back, some are look forwards, some are present perfect, some are past perfect. So it makes sense to just hew to whatever tense the legislature gave us.
One other question I had, these are just questions on the statute, because the ins and outs. of
And I'm
how
really
this is
happy we're
working.
sticking with the statute, yes.
So in Title 80, Chapter 4, in 301.
Okay.
So this is about your argument that Chapter 4, 104 shouldn't really be considered after there's been a determination of unfitness.
Right.
So I'm confused by 84-301-1, that introductory language in 1, subject to the protections and requirements of Section 84-104.
Okay, and I knew you were going to ask that, and it does say that. And I think what the legislature is saying is that we want to be mindful that we have respected the parents' constitutional rights. But if you look at the plain language of the provisions of 80-4-104, there's always qualifying language in each of these provisions that say it applies to a presumptively fit parent, like in subsection 6, before an adjudication of unfitness. Subsection 7, until parental fitness is established. Subsection 8, it goes to the jurisdictional basis to transfer custody. Subsection 9, the right of a fit, competent parent. And the wherever possible provision finishes up with, but once you find grounds, then the best interests are paramount. So I think if you just stick with the plain language of 84-104, that tells you it has limiting language. And if you look at the old soil from which this language is extracted, is case law such as Troxel and In re JP and Santosky, and all of those cases begin with a listing of constitutional principles applying to a presumptively fit parent.
So, and yes, I noticed that a lot of the subsections in 104 they give you kind of a time period at the beginning, like
Right.
before an adjudication of unfitness or until parental unfitness is established. And definitely in 104 subsection 12,
Then it goes to, yeah.
you point out that after the wherever possible language, the next part of that subsection in 12A is if the parent is found to be unfit or incompetent based on any of the grounds for termination, then the juvenile court is supposed to consider the best interests of the child of paramount importance in determining whether termination shall be ordered. And so I wonder, some of these in 104 are from the child's perspective, like 104.8, saying it's in the best interest of the child to be raised under the care and supervision of their natural parents. So once a ground for termination has been determined and we are looking from the child's point of view, whether termination is strictly necessary for the child's best interest, could that be considered, some of these statements about it's also good for the child to keep a family together?
I think by the time you get
consider
to,
that, or?
well, none of these apply in a post-grounds context. And so the assumptions that we make about the best interests of the child in most cases are talking about presumptively fit
Can
parents.
I stop you there and just ask you, from what are you drawing the conclusion that none of these, if we're looking at these that, as Justice Peterson points out, are looking from the child's perspective, apply in the post-grounds context? Okay, so I believe that you agreed with Justice Peterson that some of these in 84-104 talk about what's in the child's best interest.
Right.
That we've stopped talking about what the parent's constitutional rights, but the legislature says it's normally in the child's best interest to be reared by a, so you said, and I just want to know where you're getting it from, that once grounds are found, right, we're no longer looking at that.
Right, then becomes very much, then we don't look at general policy statements, but we look at the specific needs.
And I'm asking you where you're getting that from, because the way I have read the statute in the past, and I'm not saying it's correct, but the way I've read it is we stop looking at the parent's constitutional rights at that point.
Right.
But what the legislature signaled with the strictly necessary and with the emphasis on the newfound emphasis from the child's point of view, which I believe was inserted recently into the statutory scheme, right? It's not that these policies go out the window at that point, but that the juvenile court or the court is asked to say, okay, from the child's point of view, right, what is in this child's best interests?
So are you looking at subsection 8, or which subsection are you looking at?
So I'm just going off of what you said.
Right.
And what you said was, we no longer look at these general policies once the grounds have been found.
Right, because there's limiting language in each one.
But I don't see the limiting language when we're talking about the child, right, from the child's point of view.
Right, subsection 8 gives you the limiting language, because subsection 8 says it is in the best interest of the child to be raised under the care of a parent. And then it says, for these reasons, the juvenile court should only transfer custody for compelling reasons and when there is a jurisdictional basis to do so. The jurisdictional basis means you have found abuse, neglect, or dependency.
So I'm with you there, but but this just says for these reasons, it can only transfer in these circumstances. I don't see anything here where the legislature says, ignore what we've said is generally in the best interest of the child. Now, I admit, right, it's probably going to be tough once grounds have been found for a juvenile court to say, okay, despite the existence of grounds, it's still in the best interest of this child to remain with their natural parents. But it seems to me that the statutory scheme holds that possibility open. And I'm just asking you to show me in the statute where it definitively forecloses it.
Okay, well, first of all, you're talking about custody. And generally, we don't litigate custody at a termination.
Okay, I'm not sure I'm talking about custody. Let's
Okay.
talk about termination.
Okay.
Okay.
So that talks about the legal connection between the parent and child. And subsection 8 is talking about transfer of custody.
And you're saying transfer of custody is a specific phase in the proceeding?
Yeah, and that generally is not litigated at the time of the termination proceeding. That's generally litigated initially in the disposition, if you already have an underlying proceeding, is litigated at that point. And then there's numerous opportunities with all the review hearings and the permanency hearing and so forth to continue to litigate issues of custody.
So you're saying 8 is primarily talking about the transfer of custody
Right,
phase of the proceeding?
right.
I thought that phase was called the shelter hearing. I am
Oh.
constantly trying to learn. Is
Okay.
that right or not right?
Well, the shelter, the shelter hearing just has to do with whether the child should still be with the parent. And it's a kind of a quick and dirty proceeding because you don't have all the facts yet. So, right, the court does make that, but that's a pre-adjudication determination. But once you have the adjudication and the court has already has made that determination by clear and convincing evidence, then the court has a dispositional hearing. And the dispositional hearing determines the permanency goal, but it can also determine the child's placement in custody issues.
Okay, so the shelter hearing, if at the shelter hearing, the juvenile court says, this child needs to be removed from this situation.
Right.
It's just like and placed in the custody of DCFS, that's just a temporary
Exactly.
custody determination, and then at the adjudication
Pending,
hearing?
yeah.
Okay, got it.
It's like a preliminary order.
Thank you.
This is still on 104.
Okay,
Do you have a different
Oh,
area?
I'm shifting gears, so.
Okay,
Go ahead.
before we shift gears,
okay.
a few others in 104 that I'm wondering when this is whether we have any cues that it should not apply after grounds have been found.
Okay.
So in 104.5, it says at all times, a parent retains a vital interest in preventing the irretrievable destruction of family life. What do they mean by at all times?
Well, the old soil of that sentence comes from Santosky versus Kramer, which was looking at termination proceedings and determined that it had to be done by clear and convincing evidence. So I think that is reflected in the statute, because when you finally get to subsection 11 is an endorsement of Chapter 4 as a way to protect the rights of everybody. So at all times, the parent maintains his vital interest. That's why the legislature requires a second proceeding about grounds by clear and convincing evidence. That's why the legislature gives the parent the right of counsel and all of these due process protections in the termination hearing to protect the parent's interest.
In 4B, the juvenile court should give serious consideration to the fundamental right of a parent to rear the parent's child and concomitantly of the right of the child to be reared by the child's natural parent. Is that anything that a juvenile court could consider in deciding whether termination is strictly necessary for the child's best interest after grounds had been found? Or do you think that one should not be considered after
Well, that
grounds?
has the phrase fundamental right. And so that's talking about the liberty interest. And as this court held in BTB, as well as the more recent In Re AH 2024 Utah 26, that at the best interest stage, we're no longer litigating the issue of the parent's constitutional rights or fundamental rights because that's already been rebutted.
Okay, I have one more 104
Oh,
question.
before you move off of that subsection,
Okay.
what do you make of the second part of that provision, though? The right of the child to be reared by the child's natural parent. If the child has a right to be reared by their natural parent, doesn't that go to the child's best interests?
Well, the presumption of fitness also includes the presumption that the child should be raised with the parent. And so for the most part, this is why we don't question what a parent does, because we presume that's in the child's best interest, and we presume that, and a child has all kinds of rights. A child has constitutional rights, right of bodily integrity, all sorts of rights. But normally we don't tease those rights separately from that of the parents, because we assume a parent knows what they're doing because they're presumptively competent. But the child's right to be raised by the parent hinges on the parent being fit and competent. And Justice Rehnquist, this language comes from Santosky versus Kramer. And Justice Rehnquist, in the dissent, includes the logic that this right presupposes that a parent is able to act in that child's best interest and meet that child's needs.
Okay.
But once you can no longer trust the parent to do that, then that right has less meaning for the child. But the child, it still might be important, and the legislature provides for that when you look at the child's emotional, physical, and mental needs and desires. So sometimes children have very strong feelings about that, and then we don't terminate their rights, but then you never hear about it because those cases don't get appealed.
Okay, I had one more 104 question. In 12B, so it's talking about in determining whether termination is in the best interest of the child. And then it gives B1 and B2. You're supposed to look at first whether there were sufficient efforts at reunification. And then the second one is whether pursuant to 80-3-302, the efforts to place the child with a relative who has or is willing to come forward to care for the child were given due weight. What is that getting at? Is that kind of presuming that if you find a relative that termination is not necessary, or how is that?
I don't think it can do that, because this specifically incorporates 80-3-302. And 80-3-302 sub 8 says the relative has to be on board with the child's permanency goal. So if the relative wants a different permanency goal, such as permanent custody and guardianship, that generally would have been litigated earlier in the case. So I think that by specifically referring to that section, that you can't say that. I just think that it's another expression of the legislature saying, and it's a look back. It doesn't say you have to look forward. It says, were given due weight. So did you hold the shelter hearing the way you were supposed to have held it?
Okay.
Any other questions?
I'd like to turn to the Court of Appeals opinion.
Okay.
You contend that the court inappropriately reweighed the evidence, is that correct?
Yes, I do, yes.
Can you point me to specific instances in the opinion where the court reweighed the evidence?
Well, the juvenile court said that one of the problems was that father could not look at the children's needs. He could only look at his desires for visitation and contact. And yet the Court of Appeals continued to extol the father for his efforts and for his desires to have more and more contact, even though he could not see how after every visit the children needed to be comforted by their grandmother. So it is more in terms of a slant that the Court of Appeals gave the evidence than what the juvenile court did. But I submit that if you look at the juvenile court's findings, they're very different than what the Court of Appeals put in its evidence statement.
Can you give me another specific example?
Well, for instance, it talked about how it said the children reported that they love their dad, and they did say they love their dad. But you also have that picture that the little girl drew of her family. This is the familial identity, which is so important in 80-4-304. She drew a picture of her family. It's grandma, sister, brother. That's her family. That's how she sees her family. She's the one who runs away when dad is on the phone. So, and also when the court of, so I think it just slanted it in terms of the father's desires, the father's needs, and whether or not there was a harm test.
Thank you.
Any other questions? In short, I would submit that this court should tie the best interest test 303 and 304, and that the provisions in 84-104, you should look at the plain language of those provisions, which most of them have limiting language in them, and look at the old soil from which that language was transported. I appreciate your time.
Thank you, Ms. Pierce. Mr. Peterson, have you and Ms. Wood worked out who goes first?
We have not. I'm happy to allow Ms. Harding to go first.
And I see that you've each taken 10 minutes, correct? You've each taken 10 minutes.
10 minutes would be fine. We could split down the middle, I suppose. All right. Are you, sharing time with Ms. Pierce or with Ms. Harding?
With Ms. Harding.
Okay, I'm fine with 10 and 10 then, Your Honor.
Okay, thank you. Please, Mr. Peterson.
About statutes extensively.
But you are arguing for reversal of the Court of Appeals.
That is correct, Your Honor.
And, okay. And Ms. Harding is arguing for affirmance.
Correct.
So maybe we should just give Ms. Harding her full time?
That's what I'm thinking.
Yeah.
If that's,
And maybe we should give Mr. Peterson his full time. That makes sense.
We usually find that people get all the time they want and more.
Yes. Yeah, typically when we're more or less on the same side, Ms. Pierce and I will be able to split time, but I'm happy with whatever time the court is willing to give me.
Okay, why
start
don't
with-
you each take 20 minutes?
Right. May it please the court. John Peterson on behalf of the state of Utah. I guess I'd like to kind of start. I mean, the general position of the state is that this case is rather similar to this court's recent case of AH, which this court decided. Obviously, that case hadn't been decided by the time we briefed it, but I think it doesn't inform the court's decision. I mean, much like AH, it basically involves what the state sees as kind of judicial overreach by the Court of Appeals. Much like AH, the juvenile court in this case set forth reasons why it believed the termination of the father's parental rights was strictly necessary. I mean, and all this court's direction has always been that the strictly necessary language requires the court to slow down and to consider whether or not termination is strictly necessary, whether there are viable and reasonable alternatives to termination. I think, as Justice Peters noticed, in 104-12b2, again, you talk about efforts to place a child as a relative. Granted, that's one of the many things. Okay, if we have a strong family unit, we have, whether it's a grandmother, an aunt, or an uncle, but we have some family cohesion, and this is a good situation. Maybe this is a way in which we could avoid termination. Maybe it's not. In this case, the juvenile court found that it was not, and the court set forth reasons. I mean, and essentially the Court of Appeals simply discounted those and made its own weighing of what the evidence suggested to it, and it found those reasons were not really adequate. First of all, the court suggested that the court simply determined that permanent custody and guardianship was categorically better, but there really is nothing in the juvenile court's analysis that suggests it felt it was categorically better. It's specifically, in this case, you're dealing with a father who has historically been incarcerated for most of his child's life, 5 years. That was what the sentence in this most recent time he's been incarcerated for. He's a man who's been very unstable, as the grandmother testified. At record at 304. This is a man who has a history of making bad decisions, and she was rightfully concerned that he is going to continue making bad decisions to the detriment of these children. As she testified, she's been a staunch advocate for him, and this is her son, throughout his life, and she cares for him, and she would like him to make good decisions, but she simply does not trust him to make good decisions. So on behalf of these young children, she's decided that she needs to make good decisions for them, and she needs to protect them from whatever may happen. We don't know. He gets out of prison. Is he back on the street? Is he committing crimes? Is he using drugs? What is his stability?
I don't know if this is relevant, but is he out of prison?
I believe he is. I was talking to our trial attorney today, and there.
Okay.
Yeah.
And that wasn't before the court, and I wouldn't consider it in this, but I was curious. I have a question about what statutes we should be looking at in deciding this case. So, and Ms. Pierce, this one I meant to ask you too, but as it sometimes happens, I forget until it's too late. So I'll ask you this on rebuttal, so help me remember this. But so Ms. Pierce points out that if you look at other statutes around the termination statute, that permanency is an important goal. But that is generally handled in some of the other statutes, not in termination. It's like if you're looking at Title 80, Chapter 3, I think, where you're going through an abuse, neglect, and dependency proceeding, there will be a lot more about permanency and permanency plans. But it doesn't show up in 80-4. And I think a challenge for us on appeal is that we know in these cases, and so here there were a lot of review hearings before we ever got to this termination proceeding, and the permanency goal was changed, and there are entries from a lot of those hearings, but the court doesn't specifically mention things from those hearings that are weighing on its decision toward termination, although, of course, all of it is in the court's head, right? The court has lived through all those review hearings, but they're not necessarily specifically mentioned in the termination proceeding or in the court's findings and conclusions. And in the briefing, we may or may not, sometimes this happens, but we may or may not have part of the argument based on, if you go to this particular hearing, this happened, and this happened in this hearing. And so it's hard as an appellate court, unless specific attention is drawn to particular hearings and an argument is made about why, or the court includes something in its order about why a particular decision or finding that happened in an earlier proceeding weighs on this. It's hard for us to know how to weigh those and what to do with those. But we know that that's how these cases play out. And so I'm wondering if you have any comment on that. How we should, and Ms. Pierce made an argument about the permanency goal being changed to adoption at one of these prior hearings. I think that's right. Correct me if I'm wrong when you get up on rebuttal. But I don't know much about that or why that happened. So that's a very long question. What do we do with all of these prior proceedings that inform the court's judgment?
I guess I'd say that the overarching principles of child welfare law and all of the statutes are the child's best interest and timely permanency. At least since the adoption of the Child Welfare Reform Act, because prior to the adoption of the Act in 1994, is that right? Yeah, correct. There's a problem with children languishing in foster care, and so the Act was designed to remedy that and to make sure that these proceedings have some finality. That you don't just spin your wheels constantly saying, well, maybe the parent's getting a little bit better, maybe we can kick it down the road a little bit farther. So that's part of the overarching goal of the entire Act. And obviously that comes to fruition at the permanency hearing, where the court has said, okay, can we send the child home? If we can't, then what are we going to do? In this case, the decision was made to pursue termination. And obviously there's a bit of tension between the constitutional protections and timely permanency, because it seems a different case where permanency fails, where the court finds that there isn't, maybe say there's not a statutory ground, I can't find a basis for termination, then you're in a bit of another zone where it's, and those are difficult cases, but obviously you're going to have to deal with, okay, what permanency solutions do we have that aren't termination in that case?
So I'm looking at 84-303 and 304. Is there anything in there that puts in the termination decision that you're supposed to consider permanency? I don't doubt that a court should, but do they kind of re-up that consideration at the termination hearing in the statutes? I'm just curious.
So you're saying 83,
80-4-303 and 304, so we're in the termination statute
Okay.
and the specific considerations when the child is not in the custody of the parent, and then the next one is when they're in the 304 is when they're in the custody of a foster parent. I'm just looking for guidance about permanency in the termination statute and wondering if there's anything.
I think those considerations, those are to some extent kind of common sense, mostly common sense considerations, How is a child comfortable with the provider, whether that's a parent or not? How does that relate to the child's bonding to the parent versus their bonding to a foster or kinship placement? They're essentially things, the legislature would like you to consider. And I think most of them are fairly common sense factors, nothing too revolutionary in those considerations.
Okay.
I guess I don't know if I answered your question exactly, but.
Mr. Peterson, is the state asking us to overturn or to revisit BTB?
We are not, Your Honor.
From the state's perspective, does it have a workable standard based on the statute?
It is just, position of the state of Utah and DCFS that, that the considerations that's established in BTB are valid and important. That if there are things you can do that allow you, as legislature has instructed, to preserve family life where possible, then it's really in everyone's interest to do that. So long as, again, you're looking from the child's perspective, as you discussed earlier, I think with Ms. Pierce, once you go down the roadway once you get through the grounds for termination and find that the parent is unfit or neglectful or whatever, then it's definitely, what does this child need? And it may be that what that child needs is some familial continuity, what does that look like?
I presume that if the state believes the statutory scheme is working, it's not asking for changes from the legislature, and presumably if BTB misinterprets the statute, the state would ask the legislature to amend the statute to have a more workable system. Is that correct?
That would likely be the drive. If we found there was something fundamentally skewed that was leading to poor results, but overall, other than there are occasional hiccups, but by and large, I think it's been a salutary change from the state's perspective to consider whether or not termination is always the answer in every case, and because in some cases it's not. And this is a case. Again, this is the kind of case where under a set of facts. Do we have some of the prior issues from the Court of Appeals like GB and KK? Cases where what are the family relationships? Are they solid? Do these people fight like cat and dogs? Then obviously that's probably not going to be a good alternative termination. In this case, maybe is a little bit on the cusp. The grandmother clearly has affection for her son, maybe not trust for him. Is this child probably going to are these children going to see their father again? Probably. But again, but the court found really that's a decision that the grandma should be making, because she's the one who's been looking out for them. And the Court of Appeals seemed to believe that if she felt that the vegetation was going badly, she could just stop it, and then they should litigate in the courts. And really, some of the permanent custody and guardianship is designed to really kind of insulate relatives from that, because the permanent custody and guardianship is not challengeable by the parent, and that was a specific consideration that was added to the statute to allow people like grandmother to prevent them from having to engage in this in constant litigation for the rest of their lives with the parent to try to get their custody back. That obviously the parent cannot even seek a restoration of custody when permanent custody and guardianship is entered, under most circumstances.
But they do have a legal right to visitation.
They do, and that is.
So I'm wondering about the Court of Appeals seemed to suggest that because that's true in every case of permanent guardianship, that is more of a categorical consideration regarding permanency. Do you see it that way, or do you think it's appropriate to consider in a particular case the fact that the natural parent would have a right to visitation?
Yeah, I would disagree that it's a categorical concern. I think every case is different. The I cited to HH, which is the case, again, where the children were placed with their elder sibling, yet the Court of Appeals still determined that even that, de minimis, right of visitation was something that father would pervert and use to, continue to cause harm to the children in the future. So, I mean, so again, you have to look at what are the relationship between the parties involved. And in this case, is it a relatively good relationship? Yes, yeah, it's probably relatively good. The grandmother does seem willing, and she has, in fact, facilitated visitation with the father. Yet, I mean, as things have gone along, she's found that it's not necessarily going terribly well, and it's been something that's caused the children some difficulty, causes them strain and stress, and she reasonably felt that was something that she wanted to have say over. Is it going to happen? When it's going to happen? How is it going to happen? Not have somebody who can drag her into court and say, I've not been getting my reasonable parent time, and I'd like you to set forth what reasonable parenting is. We're going to have a schedule. I'm going to get that, every week, every month, whatever it is. And I mean, and that was probably the juvenile court's primary consideration in this case is to making sure that she is the decider, the person who, end of the day, gets to make those decisions on behalf of the.
One other question about the Court of Appeals decision. It states that really the court shouldn't have considered the children's expressed desire to be adopted by grandmother because the juvenile court hadn't made that capacity determination, whether they had the capacity to express those views. What is your position on that? Does that determination, the capacity determination, have to be made before the juvenile court can ever consider the child's expressed wishes?
I mean, I think it should be made. It'd be better. I mean, I think it would be better if the court had, made some determination about what they're. I mean, I think it probably, in a case where the court is finding, to say the opposite, like specifically these children don't want to be adopted. I think it's in the reverse consideration is particularly important. That I've spoken with the children. I've seen them. They seem to have the capacity to understand what this is about, and and I'm taking that. I mean.
So in that situation, would the state or the guardian ad litem, though, have a duty to object to that and say we want the court to make a capacity determination? I'm just wondering I'm wondering if this issue is preserved. Did the father ever object to that testimony or say that the court needed to make a capacity determination before considering it?
To my recollection of the record, there was no preservation of that argument by the father. I mean, I guess one could argue, play devil's advocate, that the statute requires it. It's something. I mean, I think it is something the statute requires, and I think a better course would be for the juvenile court to make a capacity finding if it's going to rely, substantially upon that. But I mean, the way I read the juvenile court's decision is that was something that it had in its mind, and it did, consider, but it didn't seem to be the deciding factor. Was really that it believed that the grandmother was a better person to be placed in the ultimate decision of deciding what kind of contact the father was going to be having with his children going forward.
What does sufficient capacity mean? Does it mean that a child is old enough or capable of expressing their desires, or does it mean that they need to have an understanding of the legal consequences of the difference between permanent guardianship and adoption and their dad having his rights terminated?
I think it'd be a little bit of both. I mean, it'd be hard. It depends on if you're talking about an 8-year-old child. Are they going to have a firm grasp upon what termination of parental rights means? They're probably not going to. If you have a 16-year-old, they probably are going. I mean, so I think as a child gets older, the fact that they really understand what's at stake probably becomes important. But
is there any case law on this? Has the meaning of sufficient capacity been discussed at all in case law?
I think there are cases where the court made the finding, it was discussed, but I don't believe that this court, the Court of Appeals, to my recollection, has discussed what sufficient capacity. I mean, clearly it must mean at least that the child basically is able to express themselves. I mean, because if you have a 2-year-old or something who can barely,
Right.
They're almost undoubtedly not going to have sufficient capacity to make any kind of meaningful statement about their future.
And I would I don't know this, not being an expert, but it seems that this is a little bit in tension with wanting to not put the children in the middle of the court case,
Yes.
right? And I'm assuming that they should be sort of kept a little protected as much as possible from the ins and outs of what is happening in court. I don't
yeah.
know.
Yeah, I would agree, and I think, to the father's credit in this case, he made a conscious decision not to subject him to being witnesses in the case, and I think that's commendable. And I think that generally speaking, especially with young children like this, I mean, you certainly don't want to put them in court and ask them whether they want to live with daddy or grandma. I mean, that's not fair, that's not right. But I think you want to know. Even with young children, though, I mean, it's something that I think you want to know. Do they have feelings about what's going on with, I mean, you don't want to cut them out completely.
Right.
And I think it informs, in another case, let's say that, it happens quite a bit, especially when you have an older and younger child. Oftentimes the older one, say, will have, more profound feelings like, I'm tired, we've been living this a long time and I'm done and I want to move. Whereas the young one just kind of like, misses daddy and it was like, I remember some good times, or the opposite. But I mean, so case by case, different children have different means, and sometimes they feel very strong. I mean, especially more with teenagers, you'll oftentimes say like, I absolutely want this. This is what I want. I mean, I don't think this is a case where these are fairly young children and they know grandma, they love grandma, they feel good. I mean, do they have really strong feelings? Probably not. I see I've just about,
Counsel,
yes.
You also argue, I believe, that the Court of Appeals inappropriately reweighed the evidence. Is that true? Are you arguing that?
I believe, I'm trying to write for exact phrasing, but yeah, generally speaking, that it took its own position on what this evidence means within.
Yeah, I'm trying to sort through that. I'm wondering if the Court of Appeals concludes that the juvenile court gave inappropriate weight or erred in the weight it gave a particular piece of evidence. Is that acceptable?
I guess I'm
trying to get at what standard we use to determine whether the court inappropriately reweighed evidence versus
to some extent, with regard to the children's expressed wishes, the Court of Appeals simply flat out said, I believe it's the paragraph. It said flat out that we give almost no way. I can't remember. It was midway through the opinion, but it clearly said, that's not something that we consider to be important at all.
So it concluded that the juvenile court erred in giving weight to that evidence.
It did.
Because no weight should be given.
Correct.
So it seems to be a conclusion that they're correcting an error in the weight the juvenile court gave that piece of evidence. When we say the Court of Appeals should not reweigh evidence, I try to dig down into what standard we apply.
I think that goes to the deferential standard review on factual findings, that when the juvenile court makes findings based upon the evidence before it, that it's entitled to some deference in that it's the fact finder who sees the witnesses in front of it, it sees their demeanor and can make, meaningful determinations about their candor, whereas, this court on the cold record merely just can read what they said. I mean, the Court of Appeals also somewhat discounted the child's testimony because it objected to the way it came in. And the court suggested that really it should come in through either an expert witness or through proffer the guardian. Proffer the guardian is a little bit troublesome because it kind of makes the guardian a witness to some extent in the case, which is obviously not ideal. If the guardian's coming saying the children said this, children said that. Whereas, it seems to me that somebody like the grandmother obviously has biases, and the court is, presumed to understand bias and be able to take into account bias. That's why the juvenile court is making credibility determinations, because it can understand the fact that this is a biased person who wants a certain result, but yet, that doesn't make the evidence inherently objectionable and inappropriate. It just makes it should be weighed with the consideration of bias in the court's mind.
Thank you.
And I do see I've used my time. If there are no further questions, yes.
I was just going to ask on this
Oh.
last point, did anyone object at trial to that testimony coming in?
I don't believe so.
And then on appeal to the Court of Appeals, did someone raise an objection to it, that it came in improperly, or that it shouldn't have been considered by the juvenile court because of the way it came in?
I believe that the arguments were more about the way it should be given rather than that it was inherently objectionable, if I remember correctly.
Okay, thank you.
Thank you.
Thank you, Mr. Peterson. Ms. Harding, I've failed to split time in a way that would be fairer to you.
It's okay.
I don't want you to feel
fine.
ganged up on. So you can take all the time you want.
Okay, I don't anticipate taking that much time, hopefully, because I think this is a really narrow case. I mean, by its own terms, it says it's kind of limited to these facts. It was very narrow, too, at trial, because we weren't contesting on fitness. We were just looking at best interests. So when you look at the facts of the case, and I think this is where the Court of Appeals came down, you've got a situation where dad loves his kids, kids love him, dad loves grandma, grandma loves him. Kids call their grandma, grandma. They're really clear she's grandma. And grandma is kind of foreseeing that there might be contact with dad in the future. She would just get some expert input on that. So this is definitely a case where we've got an intact family, we've got connections of love, and it wasn't strictly necessary to terminate. I think the juvenile court terminated because grandma was kind of fed up with dad and wanted to be the final decision maker in a more permanent way. And she was also concerned about what would happen if she were to die. And she thought that adoption would give her some more finality. I think the other key point in this case is that there was no proof that dad's visits over the 4 or 5 years, those weekly visits, were ever harmful to the children. And I think that's what the Court of Appeals emphasized a whole lot, that they were a little bit tedious.
Can I ask you a question about that? So this is under an overarching umbrella question about whether the Court of Appeals sort of went beyond looking at whether the juvenile court's decision was against the clear weight of the evidence and the factual findings were clearly erroneous, and maybe applied almost a de novo standard to look to whether they would have found the way that the juvenile court did. And I think this is one example that I'd like to pose to you. So the Court of Appeals said these haven't been harmful. But the finding of the juvenile court from the children's perspective was these haven't been beneficial for them, that they're uncomfortable, there's some avoidant behavior, running into a bedroom and needing to cuddle afterward. And so the juvenile court, I think, was finding these are not good for the children. They're not harmful. He's not verbally abusing them on the calls, but from the children's perspective, they've not been fully a positive. And the grandmother is saying she will decide with some professional advice how much visitation should happen based on whether it's good for the kids. So in deciding this based on, well, it wasn't harmful, did the Court of Appeals follow the appropriate standard of review?
I believe that they did, because, the court was just relying on what the juvenile court had concluded, which was there was no proof of harm. What there was is that the visits were kind of tedious. The testimony was that the kids had run out of things to talk about, and grandma needed to prompt them. The visits were kind of chaotic because they were in a noisy jail setting. And then also you have that classic long-distance relationship, which is really hard for anyone to maintain, much less a child. But I think what the Court of Appeals was saying is that there was no evidence during the trial that dad was unkind to the children or emotionally abusive or cruel, or that the visits were harmful to them in any way other than being a bit tedious and not really enjoying having to do them every week. And of course, dad is not in prison now. And so the visits wouldn't be those types of difficult visits in the future. And so I think that was the point, that we do have some parents who are harmful to their children in visits. And
But would you agree that whether the parent is at fault for making the visits difficult for the children isn't relevant at this stage, that we're not looking to assign blame to someone? I mean, the fact that, the Court of Appeals seems to spend a lot of time talking about how the father didn't do anything to make these visits stressful. But does that matter at this stage when we're looking just at the best interests of the child from the child's point of view?
yeah, I think it does, because we have that case that Mr. Peterson cited. I didn't get the cite on it, but it said that fathers shouldn't have visits because he'll use them, he'll pervert the visits and use them to harm the children. And you don't have that in this case. Dad was always trying to do the best for his kids. He was trying to connect with his son by listening to his son play music. He was playing kitchen with his daughter. They were kind and good visits. It's hard for kids to do a jail visit every week for years.
Well, and I certainly agree with you that there's nothing in the evidence that shows that it was the father's fault that the visits were difficult on the children. But the juvenile court did find that the children became avoidant and anxious about the visits. And so I do question your assertion that there was no evidence of harm. I mean, finding that the visits were difficult, that the children became anxious, that they were trying to avoid the visits, isn't that evidence of harm?
It's definitely true that jail visits were unpleasant, but he was getting out very soon, and the court knew that, and he's been out now for a couple of years. And so I think it was those remote jail visits, because in a jail visit, you got all kinds of noise in the background. There's a lot of chaos. And I'm saying, and I think the Court of Appeals was saying, it's really understandable that kids did not enjoy those. But does that mean that they should not have contact with a loving father in the future, especially now that he's out of prison? And so I think the answer to that is no, that there is real value.
I understand that point, and I might weigh this factor differently. But why wasn't how the Court of Appeals viewed this issue just reweighing this factor?
Well, I think they just looked at the evidence and they said, yeah, we understand kids are feeling a little avoidant and they don't love the visits, but we think that's understandable and we don't see that as proof that dad is a harmful person who should be cut out of their lives.
And you don't see that as reweighing the evidence?
I don't. I think that's what the evidence was. And, is that enough to terminate? That's what the Court of Appeals does. They say, is this evidence enough to terminate? Does it weigh enough in that scale? And they're saying no, because it's not surprising that the visits were not pleasant over 5 years, just remote visits. Kids don't like those. Also wanted to talk a little bit about 80-4-104, the judicial process for termination. I really disagreed with the Guardian's statement that these apply to different stages. I mean, it expressly states as the judicial process for termination. And I'm particularly struck by 5. At all times, a parent retains a vital interest in preventing the irretrievable destruction of family life. And that's at all times. And as several of the justices pointed out, that interest in family life is not just something that a parent is interested in, but the child is as well. I mean, a child having a lifelong relationship with a parent is extremely important. Also 12, I thought was really important. And it really points the court to what should we do to determine if termination is strictly necessary in 12B. And sub 2 under that, it says we need to look at whether the child can or was placed with a relative. So in other words, it might not be strictly necessary to terminate rights if there's a relative ready and willing to take on custody. And that's what we had in this case, is a relative with a decent relationship with father who could take custody. And I think what's really important there is that kids regarded her as grandma. She wasn't a parent. So I don't think that it was in the children's best interest to say, you know, she really is the parent and we need to preserve that relationship. She's grandma and she always will be.
Why couldn't the juvenile court draw the opposite conclusion from, for example, the picture that she drew of her family that just showed where the daughter just showed her and her brother and her grandmother? I'm just trying to figure out where the line is between reweighing the evidence and saying that the juvenile court's conclusion is against the clear weight of the evidence. I mean, did we have some evidence in the record that at least the sister viewed the grandmother as and her brother as their complete family?
Definitely, she's drawing a picture of her everyday life and what she sees. I mean, she talked to Dad for 10 minutes a week. But what she saw was, I live in a home with my grandma and my brother, and that's what she drew. And with permanent custody and guardianship, she would remain in that home with her brother and her grandmother. The only difference is Dad has some limited role. So, and it's very similar to what's going on in the case right now. Dad's working with the therapist to see, you know, which kid is ready to talk with him. And so Dad's not, you know, now that the Court of Appeals reversed, Dad's not down there saying, I must have visits. He's willing to work with the therapist and do what's in the children's best interests. So kids still have that stability. They still have that consistency. But they have a dad who's part of their lives to some degree, which will be determined by the therapist.
Could father be making those demands, though? I mean, we're looking at after, facts that are coming in that aren't really before us in the record and not in front of the juvenile court, of course. And so Dad could be making those demands, right? And that was one of the concerns of the juvenile court.
Yeah, I mean, he could go to court and he could say, I want to have visits. And then Grandma would simply say, kids have a therapist, and the therapist is not recommending that currently. Let's work with the therapist. And that's what we're doing now. But sorry.
It's okay. I was just going to ask if it was wrong for the juvenile court to at least, was it unreasonable for the juvenile court to conclude that that was not in the child's best interest, the children's best interest, to be dealing with that kind of uncertainty and that kind of conflict going forward, at least the possibility of it?
I suppose there's always some uncertainty. And there is a desire to protect children from that. But in reality, it's just a court proceeding, and at least our court is always going to be firmly focused on the best interests of the children. So at the end of the day, nothing is going to happen that harms these children. There aren't going to be visits ordered if that's not in their best interest. Dad's just going to have to sit back and wait. But it allows him to have some interaction. He can talk with the therapist. He can talk with Grandma about serious medical concerns. He's not completely out of the picture. And the kids have that benefit as well, because he's proven that he is dedicated to the children and he's staying in contact and he wants that relationship.
I'd like to ask you a little bit about the statute for a second, specifically 84-104 sub 8. And if I understand the guardian ad litem's position, it's that those general statements about what is in a child's best interests are somehow tethered to transfer of custody, because that subsection ends talking about the transfer of custody. Do you agree with that reading of the statute?
Well, I have to say it's kind of a funny provision in the center of the judicial process for termination of rights, and it's relating back to transfer of custody. So I think that the statute could have been drafted better, definitely. But I think it's echoing some of the concerns in the other paragraphs that aren't tied to a specific time, just saying that, there are strong constitutional interests here, both that the children have and the parents have. But we also understand down in sub 12 that once you've found that a parent is unfit, and we conceded that at trial, then you go over to the best interests of the child. But at that point, I would argue that maintaining that family connection is part of the best interests of the child, and that's emphasized by 12b sub 2.
Speaking of which, how do you read that? Justice Peterson was asking about what we make of 12B2 and whether it suggests that the availability of a relative to take custody obviates the need for termination. How do you read that?
I read it as 30-3-302 talks about, what type of person has preference for taking a child. So it's referring back to that. We're talking about a relative, and that term relative will be defined earlier. But this applies to termination. This is a very relevant termination concern, and that's why we have much less termination cases than we used to. And that is because now we're looking really hard at, is there a relative that this child could be placed with, even now at termination?
But why does that go to the termination question is what I'm getting at. Is that because the legislature thinks that a relative might be more amenable to a permanent guardianship? Or is there some other, I'm just trying to figure out why placement with a relative is relevant to the question of whether termination is in the best interest of the child.
Yeah, because it says a relative who has or is willing to come forward to care for the child. So that would be in a permanent custody arrangement rather than adoption. It doesn't say efforts to see if a relative wants to adopt.
I see.
No, is there a relative willing to care for the child? And in this case, there is a relative willing to care for the child.
What do you think, in terms of the child's desires, and I don't have the language in front of me, but the sufficiently capable or...
Sufficient capacity.
Yes, sufficient capacity. What does that mean?
Well, I think that means that as children mature, they have a better understanding of what adoption really is. So does adoption mean I just get to stay where I am? Just like I adopt a dog and the dog stays with me. And that seemed to be how the children understood it. It was similar to adopting a dog. And the problem with that is that they might not also understand it means that dad has no further rights. This dad that you've been talking to every week that you love, and you've told the caseworker that you love, and your dad loves you, that's severed because of adoption. So, but in juvenile court, we all understand that young kids don't totally understand that. And that's why I don't think anyone in juvenile court was too excited about what the kids had to say, because what does it mean given their age? I mean, the younger girl was 6 years old at that point. And so did she understand that? I don't know. And I think the court understood that too. And that's why it wasn't a big part of the opinion. I think the bigger part of the opinion was the juvenile court felt it's more stable and we need to protect these children against dad's desire to visit with the kids, because dad wanted to go to church with them and he wanted to go to the park with them. And the court felt like there needed to be protections against that. And the Court of Appeals said, why would we protect kids against this? So I think that's kind of what happened there. So anyway, I think the bottom line here was set forth in In Re JAL. The question is, can permanent custody and guardianship equally protect and benefit the children? And I think in this case, it definitely can, because kids, it's permanent. It's permanent custody and guardianship. So the kids will stay there. Grandmother will be the primary custodian. She will make the primary decisions. But dad is still there, and kids can have a relationship with them, in our case, when the therapists feel that it's appropriate. So I don't think I had anything else unless there are any other questions.
Thank you, counsel. Where do we stand in terms of rebuttal? Are you okay
Oh, yeah,
without?
I'm okay with that, unless you'd like to hear from me.
Ms. Pierce?
I want to begin with Justice Pierce's question, whether or not there has been a legislative fix. The answer is there has. And it became effective in either March or April of this year under 84-4-301, and they essentially make the argument that I've been making under sub 2. It says, when determining strictly necessary, you undertake it from the child's point of view, focus on finding the outcome that secures the child's well-being, and that's not, the test isn't harm, the test is promoting. include as applicable the considerations in 80-4-303 and 304, and explore whether other feasible options exist that could express the specific problems facing the family. So yes, we do have a legislative fix that pretty much mirrors my argument, that you have to look at the statutory factors.
Can you tell me where that was again, real quick?
Pardon?
Where was that?
That's
What
in
was
80-4-301. That's the section that lists the grounds. But under sub 2, they included the strictly necessary analysis.
Right, I mean, under 2D, isn't 2D essentially exactly what we said in BTB?
That's
I mean,
exactly
that
what you
sounds like a
said,
quote.
but what was happening is the courts were using this binary test and not looking at the factors in 303 and 304. And so this is saying, we're going to look at the totality of the evidence, we're going to look at all these other things, so it's just not going to be a yes-no test. It includes more than that.
But kind of hard to say we got it wrong in BTB when the legislature amended the statute to incorporate BTB.
Right, but
I mean, you're asking us to overturn BTB.
you can not overturn it, but instead of just boiling it down to the feasible options test, we're also including 303 and 304. And we're also looking at all the interim decisions, and we're looking at the totality of so it broadens BTB.
Can we look at that subsection 2 here? Was that in place at the time of this decision?
It wasn't, but this is
Okay.
answering Justice Peterson's question.
Okay.
Now, somebody asked a question about permanency goal, and the permanency goal appears 2 times in the termination statute. One, it appears under 80-4-304, where it talks about the child's ultimate goal of adoption. The second place where it appears is 80-4-104-12B2, which asks to look at whether placement with a relative were given due weight. So it's a look back, we're given due weight. But it refers to 80-3-302, and 80-3-302 sub 8 talks about the relative being on board with the child's permanency goal. So it's there by reference.
Okay, what was the thing that referred to the last?
Okay, 80-4-104-12.
Okay.
B2 says you look at efforts to place, whether former efforts to place the child with the relative were given due weight. It's a look
Okay.
back. But it says subject to 80-3-302. And 80-3-302 sub 8 says before you even get the preferential status of a relative, you have to be on board with a permanency goal.
Okay.
Okay. All the advantages of permanent custody and guardianship are still available in adoption. The parent's not precluded from, the grandma's not precluded from allowing contact and visitation and that sort of thing. Talking about the child's capacity to express, I really take issue with people saying we're going to give that short shrift. First of all, in juvenile proceedings, unlike divorce proceedings, the child is a party, and the child's desires are very important. Now, the kind of weight you give those desires, that goes to weight. But you look at the child's desires, even nonverbal children can express their desires. Even a baby can express their desires. So that's important to look at. The weight and the capacity, that's a different thing. And then under 304, you look at the child's familial identity. That's important too. And familial identity, that was expressed loud and clear with the picture that the little girl drew. And the rules of evidence say that a person of any age is deemed competent to express themselves.
On sufficient capacity, what do they mean in the statute? And the way that it's written, it seems like it is kind of you can consider the child's desires if the court makes a finding that they are
Right.
of a sufficient capacity. So I'm not sure what to do with that.
Well, there's not much you have to do because first of all, there was no objection to that. Second of all, if there's not a finding on something, then this court has to presume the regularity of, you have to preserve inadequacy of findings, and you have to preserve the regularity you have to presume the regularity of proceedings. So this court doesn't even have to reach that because it wasn't preserved. It's just all the presumptions go in the other direction.
Can I just jump in there too? I mean, it says the court has to make a determination, but it doesn't say make a finding. So do you Do you see the requirement that the court determine capacity to be a requirement that they actually make an actual
I think
finding?
at this point, since you have to presume the regularity, the finding is implicit. And the other thing, BTB said that strictly necessary is not a separate prong. It is part of the best interest analysis. So you do need to look at all the factors, all the mandatory factors, and with all the determinations that have been made to date. So with that, I appreciate this court's attention, and if there's no other questions, I want to thank you.
We thank all counsel for your briefing and your argument today. We'll take this case under advisement. Court is adjourned.